can't really say enough about him. I respect him so much. I'm so proud to have him here to talk to you guys today. He will give a talk, and then we will also do a little Q&A. So take it away, Khalil.
Perfect. Thank you so much, Dominic. And I greatly appreciate that. It's really an honor to have folks who have been doing the work for years beyond, I had just gotten into cannabis in 2018 with regards to policy specifically. So it's an honor to have folks who have been doing the work recognize, myself, because I'm really still consider myself a rookie in the grand scheme of how many folks have been advocating for the legalization of cannabis since the 70s, 80s, and through the 90s to pass the Compassionate Use Act. And then Prop 64 was the third time that we tried to introduce, or we successfully introduced a bill and got it passed. So it's really a pleasure, and I call it an honor to be around folks who have been doing the work beyond, way before me. And that's just not just in cannabis, but in every policy field and realm that I'm in. Always give respect to my elders. Not calling you an elder or old, but saying you preceded me with regards to the research and work. So good evening, everyone. My name is Khalil Ferguson. I am from Richmond, California. As Dominic mentioned, I run a nonprofit called the United Core Alliance. We're a nonprofit corporation in Sacramento, California that's really pivoting into legal services as a reflection of my policy, but my overall personality. So the first program that we launched was the expungement clinic from some of the first supporters during the pandemic when weed was labeled an essential business and we had windfall in our taxes and surplus. Cookies was one of our first sponsors, and we hadn't had the CRG grant yet. But understanding how data is important to our programs and our research, I just used the budget that Cookies gave us to have monthly programs in Oak Park and El Paso Heights and Sacramento with my connections to Oak Park Bloods and Crips and cleared some of the records, took that data and applied to the state of California for a grant using my writing skills, which got me into law school. And they gave us a $500,000 grant that we're about halfway through right now and clearing more records in South Sac and in Oak Park and El Paso Heights, wanting to expand that with my relationship now with DAs and public defenders to Contra Costa County. And as we've been working in San Diego County, I still very much stay involved with the community that we worked with to develop the social equity assessment in San Diego to also deliver similar services or assist them in whatever capacity they need. So as that grows and UCA has grown, we have a staff of about 5 now, and I have senior paralegals who probably have more legal knowledge than me. But it's been very interesting to be a young entrepreneur, young advocate, having a staff that you're responsible for their pay and their lives, and making sure they're adequately paid and have benefits. But folks who have been doing legal work longer than me and still respect my decisions as it relates to the decisions of the company. So it's been a long but quick 5 years, and I appreciate those who have gotten us here. To, I guess, preface the discussion for the night, the packet that you have is organized like a legal argument, or kind of like a legal, how I would structure a legal essay, in that we have a method called IRAC, which is the issue, what's the issue, rule, what's the rule, the law, statute, and analysis of that, and then conclusion. I omitted the conclusion for the purposes of this because we're going to talk about the conclusion, with the conclusion really being solutions to our issues. And to talk about social equity in California, is to talk about racial equity, gender equity, and essentially class equity as well. But as it relates to cannabis, we interact with different demographics who have different interests, and as such, different policy outcomes and goals in the legislature. But now, as a law student, as a legal mind, we're hindered by a number of things that generally impact our ability to implement social equity, not just in cannabis, but everywhere else. But because this is specific to cannabis, this is what we're going to be discussing. So there's nothing much in here about cannabis aside from Senator Bradford's equity bills and some of the funding to establish local equity programs that we'll get into. But to provide some context of the real issue, the issue stems from essentially our California Constitution and Prop 209. And that's what we'll kind of dive into. And as we advocate for equity in California, not just in cannabis, but in various settings outside of cannabis that are important to advancing equity and social justice, we run into a number of problems. A lot of the recent discussions, or I guess the issue of this decade is how to include diversity, equity, and inclusion, and include install equity, whether gender equity, racial equity, in programs, jobs, colleges, have more folks represented in UC system, the CSU system, et cetera. But what folks don't realize, and I talk to this with my supervising attorneys, is that it's kind of frustrating to me when we talk about racial justice, because everyone's passionate about racial justice. We all want more representation. We all want a very reflective democracy. We all want reflective organizations, corporations, and organizations, but we're not allowed to do so. So how can you be passionate about racial justice and without knowing what your constraints are? So first we'll dive into the constraints. And one of the first constraints that activists and advocates in California run into when trying to advocate for gender equity in more, let's just say for example, equity businesses or more black-owned businesses, more women-owned businesses, particularly in cannabis, is that you can't specifically say that per the law. California's Constitution, Prop 209, as you have in your packet, Section 31, bars the discrimination or use of policies that are based on or discriminate using gender, race, age, sex, etc. And we know that because that's what we advocated for. We have the Civil Rights Movement, which essentially advocated for the ban of discrimination of that. And looking retrospectively, I don't say that that was a drawback, but it has been a great hindrance in that now when we still want to solve issues that relates to how do we include more women in or get more women involved in the market, or how do we get more women in these organizations? Okay, well, we should write a law that says, well, money should go to these organizations that that support women or are women owned. Oh, nope, sorry, that's against the Constitution. But what did we just fight for? We fought for equal application of the law, right? Yes, well, when then you apply it to with regards to legal rights, that begins to infringe on the rights of others. And that's the argument that's made in the California legislature. That's the argument that's made in the courts. And that's if you've been following recent news after the decision of Students for Fair Admissions v. Harvard, that's the argument being made to challenge equity in DEI. So that is the mountain that we have to climb. So as you navigate as a advocate, a community advocate, a legislative advocate, a legal advocate, you have to be really innovative with these constraints, because now you can't specifically rely on how to achieve these outcomes or goals while not triggering the provisions of Prop 209. And I'll get into the U.S. Constitution, which is a little bit more broad, but not as narrow as Prop 209. So now we have cannabis equity. And what has been done in cannabis equity. And this is where you can turn to Senator Bradford's bills and other bills on how to to go around that. Dominic and I and some other students on the podcast are talking about the different, environments of social equity. And I say it's really based on your subjective interpretation or approach to social equity. Folks say social equity that is not based on race or gender. It's just social equity for folks who may have been impacted by the war on drugs or however that looks, or low income, a class analysis essentially. There are some folks who make it a racial justice specific approach, which I just discussed the hindrances with that. But then others, it's a legal criteria specifically, and that's the most widely used. So if you look at social equity programs there was a definition of social equity, or what a social equity, someone who would qualify for social equity benefits in California would be, you would see that that's a legal criteria that you have to meet. And that varies from county to county and city to city. So essentially, there's really not one specific approach or not one specific understanding of what social equity truly is, because different legislators have different ideas of what social equity would look like. And I guess the biggest contrast that we didn't speak about is that when we were trying to get City of Antioch to specifically adopt a social equity program or definition, they left it to the private sector. That's, the private sector is allowed to choose what nonprofit they want to support and engender, or whoever they want to partner with, which is their approach to social equity. Now, is that a wrong one? Who's to say?
Quick question. Do you want to be going through slides?
No, I'll say next slide in a second. So just still getting, before we really dive into that, I want to get into the meat of that, and then we'll do that. That's fine. But the subjective impressions of what social equity differs, which is why it's so hard. And, as you see in the background, social equity advocates throughout California are trying to argue for a much more narrow definition, because it has been over-inclusive, in that there are folks and they will cite the folks in North Hollywood who haven't been impacted by the war on drugs who are qualifying for social equity benefits at that level. And I say all that to say that social equity is not a monolith. Social equity is also easily challengeable because of the restraints that are erected by Prop 209. So as an advocate, our job and your job is to be very innovative with how we can get around that while not triggering it, because, and this is why I appreciate the law degree, when you write the law, you also have to make sure that law can withstand constitutional muster by the courts. So once you have the law adopted by the governor or the legislator, that battle isn't done. So you have to be thorough enough and innovative enough such that you can produce a statute or a law or a program, a regulation that reaches your goal and also is not unconstitutional. And that's what we're going to really get into. Those are the main barriers right now that we see in the California legislature in advancing equity, and I guess to an extent why equity programs have been so minimal in their impact to achieve their goals. Next slide, please. I went over that. Sorry, I was supposed to go to the next slide, so I apologize. Next slide after that. So the constitutional argument. There are really three things that I've seen in my research over the past 3 years that have really hindered our ability to implement equity and equity programs or actually achieve equitable outcomes in not just cannabis, but overall. So the Proposition 209, as we discussed, which is much more narrower than the U.S. Constitution, but that's really installed in the California Constitution. And Proposition 209 was adopted in 1996. The voters adopted it in 1996. So it's been longstanding for a while. So California has actually been operating in a much more narrow capacity with regards to implementing or achieving equity than the rest of the country, because we're one of the, I think one of the handful of states that have adopted such narrow criteria within our Constitution. But even if, to an extent, we survive that, there also are other protections in the United States Constitution that have been advocated for by civil rights activists, but are used against us in the pursuit of equity and diversity and inclusion. And those have been the Fifth Amendment of the U.S. Constitution, as you'll see in some case law, which really rely on due process and equal protection of the law under the Constitution, and then the 14th Amendment, which has the similar language, and the 14th Amendment is the one that is mostly cited to with regards to equal application of the law. So we can go to the next slide. And you have all this information on there, so I didn't want to read from the screen. I wasn't going to do that and do presentation etiquette. But then we go into the case law. And this research is essential because, as I mentioned, when you pass a law, you need to make sure you need to understand how the courts are going to interpret it. And this is why I say, and I've said I'm passionate about racial justice, but understanding that racial justice is a limiter, and I'd rather go for economic justice because economic justice has no constraints. And I talk to that with my supervising attorneys all the time. When we have these programs that are supposed to advocate for racial justice, but I'm like, how can you really do that when you're limited by the Constitution unless you're going to change the Constitution? And no one seems to be able to do that. So how effective really is racial justice as an advocate when you are abided by the law? So how can we get around that? Economic justice, which is inclusive of, but some folks don't like that because it's not just specific to one group. And we've dealt with that in the legislature where folks who are really pro-race or focus primarily on race don't want to rely on class to achieve these outcomes, and will kind of be grudgingly stuck with what they have, and just really be pains in our side. But in high voltage works for the city of San Jose, essentially, that was the case in 2000 where the city tried to be innovative, and we'll get into the legal requirements when we get to the Students for Fair Admissions at the end. But the city of San Jose tried to adopt a study which is based on empirical data that showed that minority and women-owned businesses were not included in the contract, in the overall contract environment for the city of San Jose. Okay, we have the statistics, we have data that says folks aren't included. Let's pass a policy that says they get either preferential treatment or they get contract set aside or preferential treatment in the contract awarding process. Well, that was challenged and they lost. The court said that just because that you have empirical data that minority and women-owned businesses are not included in your contract environment does not mean that there has been an instance or showing of discrimination, intentional discrimination by a city government. So therefore, the only remedy for such discrimination, the only way that remedy would be allowed, if you can demonstrate that there has been intentional discrimination by the government, such that the remedy is warranted by the government to reduce that. And cannabis is like in a gray area because we can demonstrate that there was intentional targeting by our communities by the government to affect the war on drugs. And I guess I didn't get into this, but the caveat or the problem is that in my analysis has been it came from the feds mostly, depending on where you are. There has not been specific evidence of the local government targeting our communities. It may vary, but there hasn't been any specific evidence in a memo. You can't find email communication where the government has said that let's target these communities specifically. And it was more a top thing from Reagan and Nixon and subsequent presidents to fund the police departments and these departments to target our community. So there's not really a specific showing that we've targeted against a specific minority group or protected demographic, so we can advocate for equity and apply that remedy. And that's been the biggest problem. A secondary problem, and that is also as it relates to cannabis licensing and cannabis businesses, there was no legal market to sell cannabis. So how was there discrimination if there was no market to exist? And you have to get this logical, because this is what attorneys are doing, unfortunately. when they challenge or develop the legislation and laws and then challenge them in court. So you have the information on there. I'll briefly go over the cases, but I don't want to spend too much time going to the semantic as a legal mind. But moving on into choral construction, that was more recent. So after the decision in high voltage, we're all, as lawyers, we're all aware of what the courts is pointing to, or what the court is saying. And the city and county of Sacramento tried it again, using more, empirical data, or trying to develop a greater relationship between the harm caused from the contract environment, and not saying that specifically that we'll grant set-asides, but we'll give like 5% additional points to women and minority-owned businesses in the contracting RFP process, so they get a little bump in score, which may give them that. That was deemed unconstitutional on the same grounds as in high voltage. So as of now, because of Prop 209, it's specific that we can't discriminate against businesses in that regard, and discrimination is defined in there, per the words from the court, from the California Supreme Court. Additionally, what the court did say that is, well, you may be able to get around this if you can make what's called a federal compulsion argument. And a federal compulsion argument, that as defined, says if you can meet the federal standard as to why you should be granted this legal remedy, then you can be awarded. The government has a compelling interest to adopt that legislation or adopt that provision and allow this instance of discrimination to depart. And as Chief Justice Roberts says, depart temporarily from the U.S. Constitution to grant such remedy. And that's how great of a legal remedy it is, that we'll depart from the Constitution to rectify this instance of discrimination. But that still had not happened in any instance in California at the moment. So where are we? Nowhere, really. This is how hard it is to achieve, equity, true equity, in the sense if you're specifically going off sex, gender, race, nationality, etc., because of how the courts have interpreted the strict application of Prop 209 in the Constitution. Now we get into Students for Fair Admissions v. Harvard, which was specifically about affirmative action in education. And when legal minds or folks who read it who are specifically in education and care about education equity, they think that this applies specifically to education. No. I've applied it to business law. I've applied it to licensing, similar to how we've done, the Supreme Court did in these previous cases. California Supreme Court did in these previous cases. And some of the language specifically from Chief Justice Roberts says that if we are to implement, if the government can make a compelling government interest, and we are to implement any of these legal remedies, they must be measurable and have a logical endpoint, because they're based on discrimination. So when the discrimination has been rectified, then the program should no longer cease to exist, because the discrimination has been rectified, essentially. So as we apply that to the business world and cannabis, in my analysis, I was asked a question about, well, how does this impact our ability to rectify the harms caused by the war on drugs? Using the similar analysis that I gave earlier, we can't, because we have no evidence. And if you want to make the evidence that in the articles that say that, yeah, I think it was Reagan or Nixon's campaign manager, we said, yeah, we targeted blacks and hippies. We knew we couldn't just specifically target those communities, so we associated them with heroin and marijuana use. But that's not enough. That's coming from the federal government as a policy priority to fund the military civilian cooperation act or whatever. That's not enough evidence to withstand a legal analysis. So then, as it relates to the business licensing and to engendering equity in the business cannabis community, there's still not enough, because there was no prior legal cannabis industry for them to discriminate against. So we have issues now. There's really no legal basis for any of our arguments. However, do I have one more on here? Yes, the unconstitutionality of the SBA's 8A loan program. And this isn't legal advice, disclosure. I have to do that. I don't want to risk my license that I don't have yet. But this was actually a very interesting point, in that I think it strikes a very great balance, in that in 1970, Congress passed a law and recognizing that there were not enough minority or protected demographics in the contract and the business world, and there were not enough support services. So they passed a law to identify specifically demographics that would fit within the legal framework for an 8A loan program, or set-aside contracts based on the stats that they found, which was supported by the record. And of course, they don't have Prop 209 at the national level, so it fit within the confines of the United States Constitution and the 14th and the 5th Amendment. So that was adopted in 1970. Using that same language from Students for Fair Admissions v. Harvard, a Tennessee district and appellate court found parts of the SBA's 8A loan program unconstitutional because it did not have a logical endpoint and they were not measuring their progress towards rectifying the discrimination done since the start of the program. So the appellate court issued an injunction. The SBA stopped the program for 2 months and adjusted their criteria and restarted it. But the main piece that I like about how Congress framed it in the 1970s wasn't based on group discrimination or what Chief Justice Roberts in the Supreme and Students for Fair Admissions said, amorphous societal discrimination, where everyone can just say I was discriminated against because they feel like they were discriminated against as a population. The 1970 bill that established the SBA's 8 loan program specifically focused on individual experiences with discrimination. And if you could prove that, then that was enough to serve a compelling government interest such that you would be afforded, business remedies. But you have to prove that you had a specific instance of discrimination, which to an extent is easier to do as an individual if you can demonstrate that you have had a racist incident or you've been discriminated against. That is a legal basis that has survived constitutional muster such that you can promote equity. So the constitutional grounds that it was challenged on wasn't about its identification of our individual, personal experiences with discrimination. It was based on just them not having a logical endpoint and then not measuring it. Again, this has a timeline and the endpoint because the discrimination must be based on something measurable and thus must end according to recent case law. And that is how case law, as an underlying, courts make law or policy from the bench. That's how the courts are influential in influencing what policies we can adopt in California and various states. But Congress also defined economically disadvantaged persons rather than people by demographic or racial group. And that economically disadvantaged piece is what I'm saying why I feel like economic justice is a better route to go for equity than racial justice because of our confines of the U.S. Constitution as well as the California Constitution. And you can read that case in there as well. Go to the next slide. So equity in California, and this is just 3 of a number. There's been so many, not so many, there's been a decent amount of equity bills that have passed over the past 5 years by various legislators. But specifically want to focus on what Senator Bradford did and how us working with Senator Bradford got a definition of social equity passed that has survived constitutional muster, but it had to have been broad to meet the California Constitution criteria. So SB 1294 was adopted in 2018 and essentially established the local equity grants program, which was initially housed in the Office of, Governor's Office of Business and Economic Development, but is now housed in DCC. No, it's still under GoBiz.
It was BCC.
BCC, and now it's GoBiz. Yes. But essentially what that does is appropriates an amount indiscriminate. It's ranged from 15. It was initially 10, but it's ranged from 15 to 30 million per year to fund equity programs and establishment of equity programs. So the assessment that Dominic and I worked on in San Diego was funded in part by a budget allocation from the County of San Diego, but also from funding from the state of California. And that usually is the first step to getting an equity program established is to do an assessment. Now we can get into the semantics of that. I'm not sure how much time. It's only been 30 minutes. I'll get into it. The issue that we touched on in our podcast is that, again, as cannabis has become commercialized, everything has been commercialized, from down to the corporate influence of the cannabis market to the corporate influence in the proposal market is what I'll call it, the nonprofit or consulting market. And everywhere you go, if it hadn't been for the Cannabis Studies program, was it established in or was it just, you and some colleagues?
No, Himmer. It was my role in Himmer that brought me to the
Gotcha. The equity assessment done in Humble was one of the first few that weren't done by commercial consultants. The one in San Diego County that was done by a group of community advocates who we all have our own organizations. However, that's not always the case. In San Francisco, I can't say in Oakland, I know in Sacramento, and various small cities, in my home city of Richmond, commercial consultants come in and can negotiate a price or propose a price that's below the market or below what we would be able to propose, usually around 30 to 40K, to do an assessment to establish essentially the policies and recommendations of how an equity program should be established. So you're having corporate consultants come in, do research, and establish policies that don't really reflect what a community would want, and specifically for my community, what my community wanted. And as we touched on in the podcast, that commercial consultant only did research for or produced results or research of cannabis arrests in the city of Richmond, a city that's had during the 90s and the 80s one of the highest murder rates relative to Oakland and other cities. They only did cannabis arrest rates from 2011 to 2018. So we pushed back and we said, "What? How did you start with 2011? That's what Richmond PD had." Oh, so just gonna, so whatever. Anyways, we're not gonna get into that. But that's kind of that's what's been going on overall in the cannabis industry. It's not just the commercialization of corporate influence in the cannabis market, but also in our ability to conduct research and thus policy. In the city of San Diego recently, I think we had concluded the county's assessment. We were trying to get that program proposal or that proposal for the city of San Diego, and a real estate company somehow or holding company somehow had gotten the RFP to do the cannabis equity assessment, and we really raised hell. They did a similar approach. They released a report and they started their analysis in 2010. And we said, oh, no. Fortunately, in that city, there's much more, there's a greater activist community and advocate community. We all banded together. I sent a very legally, my mentor said your words were too strong, to use some softer words with the city about their assessment. But we were able to be like, you should at least start with 1970. And they said, well, we don't have access. So we did research and we found a database. And said, here's the database, do your research. And we pushed back and got them to at least do the, start in 1970. But then in the final report they delivered to the city, and here's how special interest worked. I was going through it, and it was like in the fine text, it was maybe a 40-page report. And on page 38, some of the recommendations on the very bottom was to establish restaurants that allowed for cannabis consumption. And I'm like, I'm pretty sure the Business and Profession Code does not allow for the consumption of, bars, not restaurants, bars and cannabis. Like, I'm pretty sure the Business and Profession Code specifically says you can't have a store that sells alcohol and cannabis. That's already, like, they're proposing the city of San Diego to violate the law. So when I sent that to the community members of San Diego, they raised hell and pointed that out, but nothing changed. They didn't adopt it, but still, the fact that that was clearly a special interest influencing their position of having the contract to, I'm sure they have, bar holdings of folks in their portfolio to be able to benefit from their research. And that's what we're dealing with and trying to establish equity programs. And that the folks who are in the community can't even get these proposals, even though we put effort into it. We have the writing skills, we have the research skills to put these proposals together. And I know we can't be beat, but we get beat out by politics and money. And that's what the additional hardship that usually isn't talked about in equity is the influence of corporate or just corporate influence in these various markets. And cannabis is just a great example of that. So SB 1294 had great intent to establish equity programs, but they've essentially been commandeered by corporate influencers to essentially see it as a money, not a money pit, but a cash cow for them to just write proposals and kind of duplicate the same proposal, outlines and the same outcomes in various cities. And, we're left cleaning up the mess in our cities because we haven't left. We're still trying to change the policies and get these programs developed properly, but it's harder. It's easier said than done. But that's some of the hardships when we get these policies passed, because we can't really tailor the language to who we want it to benefit because of the California Constitution. So those are some of the impediments and how they directly impact us and our ability to create substantive law. SB 595, introduced by Senator Bradford, established equity waivers for equity businesses, fee waivers for equity businesses. A part of the benefit for equity businesses is that, among other things, depending on the municipality, is that state fees are waived. So if you're looking to get into cannabis business, I'm sure there's a few of us in here who can tell you how much it costs to start a cannabis business, depending on what part of the supply chain you're on. And I can tell you at minimum, at least 3 years ago, the lowest was distribution, and that was around $400K. So yeah. So the fee waivers really, I guess they help, but not in the grand scheme, but they do help a little bit. So the state licenses can range from $15K to $35K on top of the city permits. So Senator Bradford established the fee waiver program to essentially, and I'll give some of my personality come out in this, despite while I support the bill. And it's funny in our conversation about capitalism on the podcast, there are some things that I appreciate about capitalism, in that it's support of efficiency. And I went on a rant on this on my Instagram, and I was like, it doesn't make any sense for the state of California to be like, hey, we want to, we're gonna benefit or try to we're gonna wring out this cash cow and benefit from the investment coming into cannabis. So let's erect like $15,000, $35,000 permits. Oh wait, there's an equity problem. Small business owners and minority folks can't raise the capital to get into the market. So what are we gonna do? Let's not lower the barriers. Let's just pay for our own permits. And that is not the epitome of government inefficiency. I won't tell you what is. And that's how California's approach to the market is, and it's very inefficient. It does not make sense. Essentially, if we're in a truly capitalist society, that the market would weigh itself out, and the losers would just lose, and the government wouldn't have any say so when who enters the market, because folks enter the market with government help and still lose. So that's just a part of my personality as it relates to doing common sense policy. But I'm still sometimes a very big critic of capitalism. That aside. But also a part of the SB 595, Senator Bradford adopted a definition of social equity, which was intended to be well, and I'm not saying it's not well, but it was broad in that there are folks who have never been impacted by the war on drugs, like folks in Hollywood, who are eligible under this program and now are taking advantage of government subsidies, but have never probably had to struggle a day in their life. And that's the issue that Proposition 209 presents, is that we can't make it narrow, because as we talked about on the podcast, and we discovered as well, is that when we developed the San Diego County Equity Assessment and we provided recommendations, they were inclusive of race, gender, etc., because we did a deep analysis of settler colonialism and colonialism's impact on communities, and why our communities are over-policed, and why we have disproportionate incarceration rates between minority demographics. And once we adopted it and began to provide the recommendations to establish the program, Gobis said, we're not going to give you any money if you use race in your criteria. So we're like, all right, so we just did 500-page report that's thorough, and we just put all this effort in, and you're not going to give us the money, rightfully so, because we violate the Constitution. So that's the hard part in developing the policy. So knowing that, being forward thinking as a legislator, when you're crafting your policy and your bill, Proposition 209 is always a forethought when you're dealing with who's going to benefit from this, because that's going to be a basis for challenging it by whoever doesn't agree with the law in court, and they're most likely going to win, because as we've seen, there's plenty of case law to support their argument. So when developing it, it wasn't intended to be as broad, but it had to be, because if we wanted to get anything passed, we couldn't base it on the same criteria that we normally do. So when Senator Bradford passed that is the impact that we have now, that people are trying to narrow, which goes back to the first part, the issue and the rule. We still have to find a way to circumvent the issue and the rule, to which we haven't been able to do anything. So this definition has been standing for about 2 or 3 years now, and there's just no appetite to amend it, because we know what our constraints are, and no legislator wants to risk being sued, and the governor especially doesn't want to risk being sued for Prop 209 violation. So then we get into the most recent bill, SB 51, Provisional License for Social Equity. If you're not familiar with the licensing structure that Prop 64 established, most folks are on provisional licenses up until March 2nd of this year. So Senator Bradford, with social equity advocates, lobbied for an extension for 5 years for social equity companies who meet that definition. It's also interesting part is, I'm sorry, I don't want to go over it. The biggest part to me, and when I work with my colleagues who want to narrow the definition, is that it still allows for the local definition to take precedence. So if you can meet the criteria of your local definition, no matter if you narrow it at the state level, if Hollywood establishes an equity program and they qualify under Hollywood's equity program, then they just qualify for equity benefits because Hollywood has an equity program. Should Hollywood have an equity program? That's a normative question that I won't answer. But SB 51 was an attempt to allow folks who have social equity status from the state or the local government another 5-year extension, because equity businesses are just now getting into the market, and it's unfair for them to have to go get an annual license and meet CEQA requirements and such, while having less opportunity to get into the market. So the rest of that is the funding from SB 1294. Next slide. Funding from SB 1294 over the years since it's been implemented. I omitted 1 year because it was a mess when they adopted it. They adopted it, and the first round of funding took 2 years to come, and it was only $10 million, so they had 2 rounds of funding in 1 year. So I just omitted the $10 million a year. Right. Yes, I remember that. They were humble that they. It was humble when. we'll deviate for a second. Humboldt being listed as a social equity participant through a lot of the, and this is where I've come in as I work with Ross and Janine Coleman at the Origins Council frequently, and they're very good allies and friends of ours. I like to say I represent the urban community, and when we work with them, that they represent the rural community in policy, because policy is also very divisive. So what has come about, and is still very long-standing, and we're trying to remedy it or rectify it, is the division between urban communities and rural communities. So when Humboldt popped in the scene as a social equity, uh, area, municipality, or geography, the urban communities were like, Humboldt didn't experience the war on drugs. I'm like, that's because you didn't do your research. And as I brought up on our podcast, what I will always be intentional about bringing up is the fact that we can't ignore the fact that camp was a focused primarily in the Emerald Triangle. Yes, these studies we all know, and we often show that the urban communities have been over policed. Crack was introduced into in Los Angeles intentionally by the government, and these communities have been specifically over policed and over incarcerated and subject to that. But I have to make sure that we all thoroughly know our history. And we didn't have, as I said on the call, we didn't have camp federal agents with the sheriff flying 50 feet over the tree line or 50 feet over our home to come down and take our plants. That is a different level of trauma, where we have a dirty bird over our house maybe 300 feet in the air just circulating the police in the community. But to have federal agents circling your house 50 feet above it and invading what case law has said your air rights is a different level of trauma that we have to acknowledge. And that's what I've been trying to make sure that the urban community is aware of, or takes account for when we talk about social equity. Because when Humboldt hit the scene, there was a lot of essentially xenophobia, I would say, for lack of better terms, regarding Humboldt's input or inclusion in the equity funding. So just some other things that have been included that you won't find, because a lot of our plays, when there is a surplus in the California budget, as you know, we're in a fat deficit this year, usually go through the budget. So you won't see like an AB insert name here. You'll see AB, whatever the budget trailer bill is, which is like 200 pages long, and you'll have to navigate to find these, the budget allocations. But in certain other ones have been, of course, the local equity grants program. There was a vendor compensation program that gives equity businesses a 20% discount on their overall excise tax bill, which equates to a 12% effective rate. As opposed to charging 15% on your products, the equity businesses, if taking advantage of this program, can charge 12%, which is some economic advantage, but not much in the grand scheme because of the overtaxation and regulation. And if you're familiar with additional problems with cannabis businesses, as we discussed in the car on the way here from the airport, 280E issues. That's a big conversation right now, and not being able to. Cannabis is treated so much differently as a business than anyone else. It's really unfair. And for background, before I dive into this, I'm studying specifically corporate law and cannabis in law school right now. I'm working on a project with a corporate law professor and one-on-one, called federal securities regulation. And he's giving me like a plan, or like having me navigate the laws to take a cannabis company and go and do an IPO, and navigate all the laws that may impact that ability for that. So really understanding what impacts a cannabis business. And 280E comes back as one of the biggest problems. If you were to add up the effective tax rate from the state taxes, from the sales taxes to the local government taxes to the state tax to the corporate tax, it ranges from 60 to 70% effective taxes that you can't recoup. And 50% of that is gross on your revenue, not tax on your profit. And 280E does not allow you, federal 280E does not allow you to recover the cost of labor and the cost of producing the goods as you would any other business. So there's not many deductions that you can claim on that under that IRS tax code. California, for a certain amount of years, has allocated the budget of $20 million for those who work with bona fide labor peace or bona fide unions under a labor peace agreement, and for social equity businesses as well, to take advantage for those who work with the unions and have a valid labor peace agreement to have up to $250,000 a year reimbursed from the state for state taxes. But that's still a drop in the bucket for these businesses. So these are ways that we're trying to be innovative with our approach to equity, given the confines of Senator Bradford's equity definition in SB 595, and then just generally applying money, so we can just try to throw money and alleviate the costs, so we can compete in this market or keep this market sustainable. That's all I have for slides. We can definitely open up for Q&A. Next slide, I just want to double check. Next slide. Perfect. Thank you guys. If you have any questions, we can open up for Q&A, and I'm happy to answer any questions.